Is it okay to temporarily lay off full-time employees, or does it expose an employer to constructive dismissal claims?
Great, thanks, Rob. And I should mention, we're not putting anyone's name here. We're kind of assuming that if you write into us and say, if I do something, can I be fired? You probably don't want everyone to know who you are and where you work. So we're keeping everything anonymous today. But this is a great question. It hits upon one of the most common misconceptions that we deal with. Everyone assumes that every new hire has a built-in probation period. And the legal reality is exactly the opposite. There is no automatic right to either have a probationary period or to lay employees off. And that's the other assumption that people make, is that you can lay people off short term. There's a slowdown, there's a seasonal slowdown in work, there's some other reason why things are slowed down, but it's only temporary. A lot of employers assume they can just tell the employee, don't come in next week. And the reality is that legally there is no automatic right to temporarily lay off employees. And it does, in fact, constitute constructive dismissal, which is exactly what our viewer asked. So taking a quick step back, what is constructive dismissal? Constructive dismissal is a substantial change to a fundamental term of the employment relationship. And really, what could be more fundamental than providing the employee with work for pay? So when you tell the employee, you can't come into work, we're not going to pay you, you are fundamentally changing the agreement, even if it's just temporary. And that is a breach of contract, or in this context, constructive dismissal. The only time an employer is allowed to do this is if they have a contractual right, and that can be explicit or it can be implied. Implied would be situations like, for example, the construction industry. We all take it for granted that at certain times of year, things are slow, construction workers might be told to stay home for a while. It would be pretty easy for most employers to argue that it was implied. Everyone knew that this was a possibility. In most cases, if you're an employer, you're going to want to put that right in the contract so it's clear and explicit. The reason there's a lot of confusion is because if you look at our employment standards legislation, including the Act in Ontario, it sets out the limits for temporary layoffs. And it basically sets out how long you can lay someone off for before it becomes a termination. So people see that and assume, okay, well, I'm allowed to temporarily lay someone off. And the reality is, this is quite misleading. It sets out the limits for what you can do if you have the right. But if you're an employer and you want to have the right to lay people off temporarily, now and again, or if it happens one day in the future, it's got to be in the contract. Never assume that you have the right. And if you're an employee, I've often, come across people who were temporarily laid off and just assumed that they had no rights, when in fact they could have filed a claim at that point and then never did anything because they didn't know the rights, they didn't see an employment lawyer. One of the things that's interesting, I mentioned the outset probationary periods. That's the other most common misconception or assumption. Everyone assumes that every employee has a probationary period built into their contract, which is also not the case, even though if you look at the employment standards legislation, there is provision that in the first 90 days in Ontario, first 90 days of employment, you can be let go without notice and without cause. That's only if the contract confirms this. So again, don't assume. I have mentioned this before. I'm the director of a course called HR Law for HR Professionals. One of the things that I really try to drill into everyone during that course is that there are so many legal regimes that govern the employment relationship. We're talking about employment standards, we're talking about human rights, workplace safety, occupational health and safety, we're talking about privacy laws, common laws, I've run out of fingers, labor laws. There are so many different regimes. You need to be aware of everything. So for example, if you're an employer, and I've seen this happen to people, where an employer wonders, do I have the right to lay someone off temporarily? Things are going to be slow for the month of August, for example. And they'll look up the Employment Standards Act online and they'll see, oh yeah, it looks like I do have the right up to 13 weeks. And in many cases, they will even call the Ministry of Labor and double check that. And they will be told, yes, under the Employment Standards Act, you have the right to temporarily lay people off. The problem is that they don't look into the other laws, such as the common law, the law of constructive dismissal, and they end up making mistakes. And I've seen this happen. We had a client a number of years ago now who called the ministry and they were told, yes, you can lay someone off. They laid off a 10-year employee for a period of about 17 weeks. Ultimately were sued for constructive dismissal and found themselves on the hook for a significant payout, in addition, of course, to the legal fees, all of which could have been avoided with probably a 5-minute call to an employment lawyer. So to come back to the question, can you temporarily lay employees off? Maybe, but only if there is either an implied right based upon the industry or the company, or even better, an explicit right built into the contract which says we have the right to lay you off in accordance with the applicable employment standards legislation. Otherwise, it's a constructive dismissal.